So the case is about a trustee, Pamela Burge, who is basically trying to shift the consequences of her own voluntary conveyance of real property onto my client, the buyer, Kelly Blake, who quite literally did nothing wrong uh, in this case, as the underlying complaint suggests. So, uh, what is truly undisputed in this case is that the successor trustee, Ms. Pamela Burge, who has assigned her claims to this plaintiff, Delane Schultz, signed and delivered a facially valid statutory warranty deed that conveyed two parcels of real property to a willing buyer, my client, Kelly Blake. So plaintiff's dispute here, Mr. Schulze's dispute, and Mr. Schulze and Ms. Burge are brother and sister, is really with the sister trustee. It's not with my client, Kelly Blake, as to why she did what she did at the time of this conveyance. There's really no genuine issue of material fact here because it's a purely legal dispute based on the causes of action asserted. And the causes of action that have been asserted against my client are breach of contract, void deed, specific performance, and unjust enrichment. And over the effect of the statutory warranty deed itself, which is particularly appropriate for resolution on summary judgment. So I'll just take the causes of action that were asserted in the complaint one at a time. And the first one happens to be a breach of contract. So first of all, if you look at the complaint, there's not a single allegation of breach as to Ms. Kelly Blake, the buyer, at all. The allegations are directed against the broker. So there's no contractual conduct by Kelly
and
Blake.
The broker being Stewart or some other entity.
I believe we're talking about the real estate agent here.
Okay. That's Dusty Karloff. Is that who we're talking about? I just want to make sure I got the cast of characters correct here.
That's correct. Dusty Karloff.
Okay, thank you.
Now, on top of that, even if there were somehow a breach of contract by this buyer, Ms. Blake, the contract on which this theory of breach is being based is the purchase and sale agreement, which has already merged into the deed upon its execution and delivery, and that's black letter law. So once the deed is delivered by the seller, then that becomes the final expression of the party's intent. And so for that reason, the breach of contract claim against this buyer, Ms. Kelly Blake, cannot survive legally. The second cause of action, and I'm not totally sure that it is a cause of action, is labeled as a void deed. But Washington law on the issue of what makes a deed facially valid or invalid is very clear, that a valid conveyance by deed requires a signed writing with a sufficient legal description that is signed and acknowledged. And we have all of these present in the case. We have a signed writing. We have a very specific legal description that describes two parcels of property. The deed is signed and acknowledged. And so that is exactly what the trustee, Ms. Pamela Burge, delivered to my client, buyer Kelly Blake, at the time of this conveyance. And that is the deed, the statutory warranty deed that has been recorded. Now, there are all these other allegations by by plaintiff Schultz vis-a-vis his sister, Pamela Burge, but those grievances literally should be taken up between the two siblings, not Ms. Blake, because Ms. Blake did nothing wrong. She was given a deed, a valid, facially valid deed at the time of this transaction. On top of that, it's the legal description of the property at issue that governs, because there's a lot of discussion in the opposition about, and the complaint about.
This is the defense's main argument. They're telling the judge that Kelly Blake was simply an innocent beer who relied on a signed and legally valid deed. According to the defense, if anyone made a mistake during the property transfer, that dispute belongs between the family members, not the beer who purchased the property in good faith. Now the court has to decide whether that argument holds up.
The tax parcel numbers. Well, tax parcel numbers are not legal descriptions. They're administrative. The legal description in a deed is what's going to control each and every single time if there's a legal description. You could have 0 tax parcel numbers in a statutory warranty deed. But if you have the legal descriptions that describe the property that is being conveyed, that statutory warranty deed is facially valid. And we cite to a case, Lawson v. Bankers Insurance Company, a very recent case, as a matter of fact, the 2025 case. I forget which division the case is out of, but the court unequivocally holds that a court may not disregard a legal description in a deed under a theory of construing it, and that is precisely what plaintiff would be asking this court, and it is in fact asking this court to do. On top of that, a person who signs a binding contract cannot later claim that she did not read or did not understand what was signed. That's black letter Washington law, and that's precisely what the trustee, Ms. Burge, is trying to tell the court here. Well, I didn't really understand what I was signing. I thought that I was signing this, but it turns out that I was signing that. There's a policy behind this basic legal maxim that if you are signing a contract and you're given an opportunity to read it and understand it, you're entering into a binding legal transaction, and it would if you can in fact dispute every single transaction that you have signed because you claim that you didn't read or didn't understand it, it would just render all of these real estate transactions and other binding contractual agreements meaningless. Ms. Burge, the trustee who had executed the deed, admitted to reading and approving it. There are documents that support that in the record, and the legal descriptions were approved by Ms. Burge before signing. Now, whether or not she knew or exactly understood or can read legal descriptions is completely irrelevant. The third cause of action asserted, I don't believe, is a cause of action. The claim is for specific performance. The specific performance is a remedy that is based on, it's a contract remedy, but there's no actionable breach of contract by my client, Kelly Blake, that has been alleged. And so therefore, our argument is Ms. Blake did nothing wrong. And there's no breach of contract as to Ms. Blake. Therefore, the remedy of specific performance is also unavailable to Plaintiff Schulze, and we're asking the court to rule to that effect. And then finally, the last cause of action that it was asserted as to my client, Ms. Blake, is unjust enrichment. Now, unjust enrichment here is barred because we have a valid statutory warranty deed, a contract. And so this deed governs the parties' rights at issue. Equity in this particular situation is not going to override a valid and a fully executed conveyance by statutory warranty deed. It appears that plaintiff has already sued his sister, Ms. Burge, for fraud. Now, what appears to be happening here is that plaintiff is trying to backdoor the same grievance into claims against an innocent purchaser for value, my client, Ms. Blake. Allowing this to proceed would basically be completely counter to established Washington real estate law.
Anything else?
There really is not much else to add.
Okay.
At this
I
point,
may
Your
have
Honor,
a
but
few
happy
follow-up
to take-
questions. Thank you. I don't mean to cut you off, but I'll have a few follow-up questions maybe after I hear from Mr. Nelson. Mr. Nelson, go ahead. And I just want to make sure I understood, Mr. Nelson. So I read your plaintiff's joint response to defendant Stuart Title and Kelly Blake, the summary judgment. I think you've put it in one document, which is fine. I just want to make sure that you intended for me to look at that document, correct?
I did.
Okay, so Mr. Nelson, if you could focus for me, responding, of course, to what you just heard, but the issues that it might appear that you are not disputing everything in Kelly Blake's motion for summary judgment based on your response, but perhaps you are. So perhaps you can clarify what you're disputing and what you're not vis-a-vis this particular defendant.
I will focus on where I think the issue of fact is.
Okay.
So in this case, where I think the court needs to look is that Kelly Blake and Delane Scholes received a deed to the same property dated the same day from the same person. Scholes recorded his second, which is one day after the Blake deed was recorded. Under the case of Levian versus Afiala, Schultz would have the burden to show that Blake had actual or constructive notice of his interest in the property when she recorded her deed. If he's able to do that, then as to the 90 by 100 foot lot, the deed is potentially voidable. There's several documents
Sorry,
that raise
Counsel,
an
what
issue.
was that? Counsel, what was that? Can you give me a citation one more time?
The case is Levian versus Alfiala. It's in my brief on page 8.
Oh, okay, great. I'll get it from there. Thank you.
Okay,
I see it in
you.
the footnote now.
all right. So there's several documents that show that Blake had notice of the Scholes interest. First, the purchase and sale agreement only lists parcel number 60947, which is the house lot, not the 90 by 100 foot lot, which is 60938. The property profile generated by Stuart Title only lists the house parcel number. The legal description of the property on the property profile accepts out the 90 by 100 lot. The deed that Ms. Burge signed prior to alteration only lists the house parcel number, and the abbreviated legal on the face of that deed accepts out the 90 by 100 lot. And the excise tax affidavit only lists the house parcel number. So all of that shows that the 90 by 100 lot parcel number was nowhere to be found in those documents. Then there's the discussion with Pamela Burge that came within a month of closing. She goes out to see Kelly Blake. They discuss the Scholes parcel, and Miss Blake asks whether my client, Mr. Scholes, would be interested in selling it. There's no declaration from Miss Blake, so that testimony at this point is undisputed. All of these, both the
Well,
documents.
why
and the
does that
testimony-
matter? Why does that matter?
Because it shows that she may have an understanding at the time she closed this transaction that the 90 by 100 lot would go to Mr. Scholes. And under the case that I cited, where two people get a deed to the same property, if she has an understanding that that parcel goes to Mr. Scholes, then the deed is potentially voidable as to that particular lot. And so these documents and that testimony suggest that she did have an understanding that she was not to receive that lot, that it was only limited to the house property.
But how does that, I'm confused. So I'm looking at your deposition testimony. This is page 15 of Pamela Ann Bergy. I'm reading it. Page 29 of 32 of your exhibits. I'm unclear how you're creating a material fact. In other words, Ms. Bergy doesn't say, yeah, she clearly had notice on the date of the sale that it was the wrong lot. I mean, I don't know how it creates a material fact on the date of the sale, at the time of the recording. How this testimony is enough to say, well, she had notice on the date in question of the original transaction. Like a month later, maybe she heard through the grapevine, I don't know, from the recorder's office, hey, the other person tried to come in and record on that same lot the next day. Oh, that's weird. How does this affix her knowledge at the time of the transaction?
But isn't that for a jury to determine? When Ms. Burge says that she went over there was, and that's the reaction she had, was, what would he sell it? It shows prior knowledge that she was aware that that parcel was not to be conveyed, and that is consistent with the documents that I've just referred to.
Okay. Continue, counsel. Thank you.
Your Honor, that's it. That's where I believe the issue of fact is in this case.
Okay. Well, so let's presume for the sake of the I'm going to turn that over to Mr. Bogdanov for a minute. Let's presume for the sake of the argument that that deposition transcript creates a dispute of fact. Does that apply to all of your bases for motion summary judgment, or are there still matters wherein motion for summary judgment may be granted? And I'm thinking particularly, I'm not quite understanding how that reaches, for example, a breach of contract claim. Again, maybe it goes to an equitable thing. I'm not quite understanding how that creates a material fact on a breach of contract.
You're asking me?
Well, yeah. Does any of let's assume that there's a dispute of fact that is created by that deposition transcript. Do any of your bases for filing a motion for summary judgment, because it incorporates several claims, do all the claims die, or are there still some that may be disposed of through summary judgment?
Well, I'll start by saying, first of all, at her deposition that we quote and attach as an exhibit, Ms. Burge explicitly and expressly admits to having no contact with my client prior to this meeting after the transaction had already closed. And then she proceeds to speculate at counsel's urging that there was some question or some kind of reaction that she saw in my client. So that is not, first of all, that's not admissible testimony, but second of all, that doesn't create an issue of fact. We can assume for purposes of your question that it does, but my argument, of course, is that it does not.
I understand.
This is a post-transaction conversation, and we have a very clear record of Ms. Burge having testified that she did not have any contact with my client prior to this meeting. But to your point, all of this extrinsic evidence is not going to be admissible to contradict the intent of the parties at issue, which is subsumed in the statutory warranty deed that we're looking at. We have a legal description of two parcels that has been signed and acknowledged and delivered to my client. All of this extrinsic evidence has zero bearing on our request to dismiss the causes of action that have been asserted in this case. Now, Ms. Burge may have grievances vis-a-vis, or I should say plaintiff should have and may have issues vis-a-vis the trustee, but not vis-a-vis my client. There's no issue of material fact as to the validity of the statutory warranty deed. I have recited the law that applies to what makes a Washington statutory warranty deed facially valid. There are no acts by my client, Ms. Blake, that indicate that she may have breached any sort of contract here.
Now, the plaintiff is fighting back with a completely different theory. Instead of claiming the beer did something wrong directly, they're arguing she may have known that part of the property wasn't supposed to be included in the sale. If they can prove the beer had prior notice, it could completely change how the court views this transaction. That's now the biggest issue in the case.
Therefore, there's no way for the court to order specific performance. And equity doesn't come into play because we have a statutory warranty deed that is valid on its face. So my response is, yeah, no, there's no issue of material fact, period, based on the testimony. And two, all of the causes of action, of course, fail, even if we were to assume that this testimony comes in somehow.
All right, thank you. Any brief response to that, Mr. Nelson?
No, other than on the specific performance, if the court or a jury were to find the deed, at least as to that lot, void, then it would invalidate the deed to that and may end up going to my client.
But what legal mechanism would allow the jury to find that deed void? Have you asserted a claim of fraud against this?
It's under the mechanism that my client received a deed to the same property that was deeded to Ms. Blake. And so that has to be sorted out. And if Ms. Blake had prior knowledge of Mr. Scholl's interest in that lot, then potentially that portion of the deed would be void. And the documents that I've discussed and the testimony by Ms. Burge at least raise an issue of fact that needs to be determined by a judge or a jury as to whether that shows that Ms. Blake had knowledge of Mr. Scholl's interest in that property.
Give me a moment. I want to review this deposition transcript before I make my ruling. I may be wrong on this, but I don't believe that the deposition even if read in totality with the documents attached to plaintiff's response, I don't think even under a totality, it creates an issue of fact that necessarily has a legal I'm struggling to use the right word, implication, but this is a vague statement in the deposition transcript. She must have knew because she asked if you would be willing to sell it, but that in no way suggests that there is a fraudulent conveyance, and I didn't see any fraud alleged in this case or a conspiracy to commit fraud or anything else. There's a very bold, long after the fact statement that, they asked me if they'd be interested in selling it, and maybe. Well, again, that in and of itself, I don't think creates a material issue of fact as to what at the time of this contract, which is binding contract, was known by Ms. I'm going to get the names. I want to get the names correct here. Ms. Blake. In other words, this statement is very I don't know, circumspect would be the best word I can think to describe the deposition testimony. But more to the point, I'm not sure that it matters, Because for all the reasons pointed out, we have, again, I'm not seeing a breach of contract. There's nothing that I see in the evidence as to breach of contract. Okay, maybe maybe Ms. Blake had some form of notice. Okay, great. But how does notice that maybe there's some other interest create a breach of contract claim? And I haven't heard any argument as to how exactly what legal theory would create that. Second, again, we talked about there was discussion of the merger, and again, there was a valid contract, there was a PSA, there was merger into the deed, it was signed off. And I haven't seen any claim of conspiracy to commit fraud or fraudulent conveyance or any other theory here that would somehow explain a conspiracy between the buyer and the seller that would, for lack of a better term, perhaps vacate the merger of the PSA and the deed. I'm not seeing it here. Counsel for the plaintiff, does that give you enough to work with? I can be more explicit in my thought process if you'd like me to go make a written order. But I'm not seeing a sufficient dispute of fact here on the claims that are being, or on the various theories that are being raised in the summary judgment to deny summary judgment. Sorry, Mr. Bogdanoff, that question was to you. I apologize.
Oh, sorry. Yeah, I thought you said counsel for plaintiff. Yes. This is perfectly sufficient. You're on.
So let me see. Again, the specific performance, I'm not, I'm confused again by why I would not grant the dismissal of the specific performance to the extent that that's a claim and not a remedy. That might be a remedy, but I don't know that there's a claim upon which that remedy can lie. But again, I'm not seeing anything that would, as to defendant Blake, require Blake to do specific performance. There may be other remedies available if I were to find a different way, but I don't see how specific performance is one of them. Finally, on the unjust enrichment, again, there's counsel involved, representation by a listing agent. There was opportunity to review the documents with the involvement of counsel. And again, I don't see any basis by which unjust enrichment would be available as a remedy. Again, maybe if there was a fraudulent conveyance or something akin to a fraud action here, it maybe go a little differently, but I'm not seeing it at this moment. So for all those reasons, I am going to grant summary judgment. Counsel for the moving party, do you want to prepare an order and circulate it?
Certainly, Your Honor. We do have a proposed order. I believe that we had sent to chamber.
Do you need me to clarify anything else in my ruling before we do a written order? Any questions from anyone?
No questions here, Your Honor.
No questions at this time, Your Honor.
I'm looking to see if I've got a written order. Give me a second, gentlemen. I am not seeing it. It's quite possible that there is one around, but I am not seeing it up here. Clerks, did we get an order on this case by chance?
No, we're happy to resubmit, Your Honor.
If you can resubmit, that'd be great, because I'm just not finding it at the moment.
If you email that to me, I may be able to just sign off on it, and then it can be signed.
Yeah, we can do that.
Okay. And then just the forecast. So what is our plan for the 4th? Just so I can have a sense of it.
Yes, Your Honor, that will be Stuart Title's motion for full summary judgment. So dismissal of all claims against Stuart Title.
Okay.
And we'll do our best to keep it to 10 minutes.
Well, I appreciate that endeavor, but if we go over, we may go over.
Well, I
and
think
actually-
that, yeah.
Yeah.
Sorry, I was gonna say, I think the ruling today is helpful from that, and the court's well aware of the background. So Mr. Nelson and I will be as efficient as possible.
Well, I would note, so here is something I would offer to both of you. I will not be on the bench on the 4th. It'll be a different judge. Normally, I will be handling the civil docket, but on the 4th in particular, I am unavailable that day, so it will be a different judge. If you want a different judge to take a separate look at it, keep it on the 4th. If you want me to have it, you can renote it for the rest of the month. I'll be available, just not on the 4th. So I just put that out there so that no one is surprised. You all can figure out what you want to do with that, but it will not be me sitting on the 4th.
I would
Thank you, Judge.
suggest we move it to the 11th. I don't think it makes sense for another judge to review everything.
We can do that today by agreement if you all want to move it over to the 11th. Is there, I don't want to force it, but is there anyone who's unavailable on the 11th?
I'm available and agree to moving it to the 11th, Your Honor.
Mr. Bogdanov?
I'm generally available.
Okay, so let's go ahead and set it to the 11th. Clerks, do you need them, counsel, to do anything? We don't need a renote. You can just, okay. My clerks will take care of it, so we'll move it over to the 11th. I'll keep a hold of all the pleadings to the extent they're relevant from today's hearing. And then if there is a dispute over the form of the order, just cite it on for the 11th so we can take it up all at once for efficiency's sake.
After hearing both sides, the judge wasn't convinced there was enough evidence to send this dispute to a jury. He ruled that the plaintiff failed to show a genuine factual dispute against Kelly Blake and granted summary judgment in her favor. While the broader lawsuit isn't over, this ruling removes the beer from the case and leaves the remaining claims to be resolved separately. If you enjoyed this courtroom breakdown, hit that like button, share your thoughts in the comments, and subscribe for more real courtroom drama and legal analysis.